I'm joined now by Carol Lam, a former U.S. attorney and a former Superior Court judge, and now, lucky for us, an NBC News legal analyst. So, Carol, from a legal standpoint, how much damage do you think Donald Trump did to his defense in the federal election interference case? Like, are we going to hear that answer played in a federal courtroom?
Probably, Garrett. I think we all recognize by now that every time Donald Trump grants an interview or speaks in front of a crowd and opens his mouth and talks about the events of January 6th and who was in charge, he starts eliminating some of the arguments that his lawyers can make. So, yes, all of the prosecutors out there are taking notes, and whether or not Donald Trump takes the witness stand, these segments can be played. They are a defendant's statement, and under the law, a defendant's prior statement can come in whether or not that defendant takes the stand.
Forgive me if this is too in the weeds, but given the nature of the Georgia case and the idea that Trump was somehow orchestrating this broad, racketeering conspiracy, that's essentially what he's charged with, is an answer like that it was coming from his instincts, that he was calling the shots, as Kristen phrased it to him, is that more damaging in Georgia than it is in the federal case, or are we splitting legal hairs here?
I wouldn't say you're splitting legal hairs, but the answer is actually it's not more damaging in the Georgia case. It's actually equally damaging to Donald Trump in both cases, because both cases essentially charge the same crime, that he wanted so badly to be declared the winner of the 2020 election that he would do or say anything. And the scope of the conspiracies that are charged both in Georgia and in the federal case are really quite broad, and they span many, many states, and they span a lot of conduct. And so if Donald Trump is out there saying, I was in charge, I followed my own instincts, he takes away in both cases the ability of his lawyers to say, well, he was just relying on advice of counsel. That is what his lawyers were saying. And Kristen Welker in the interview was pretty clear about saying, which lawyers did you depend on? And he said, well, I didn't. Lawyers told me different things, but I was the one who made the decision. I
want to ask you about another very thorny piece of law here, with prosecutors now asking for a limited gag order in the federal case from Judge Chutkan. They're worried about the former president attacking witnesses and so forth. The judges have made it very clear they don't want to go down this road. I wonder how likely you think it is that Judge Chutkan will grant this request, and if she does, how she'll enforce it.
Well, they don't want to go down this road, the judges, but they will if they have to. And I think Judge Chutkan is going to impose some limitations. The motion filed by Jack Smith asking for a narrow, limited order restricting what the former president can say, it was very limited, and it said statements having to do, derogatory statements having to do with witnesses, court personnel, potential jurors, individuals. And it then explicitly said our requested order would not impact his ability to talk about his innocence or to quote from any pleadings that have been filed in the case. So they are trying to be narrow and give the judge some basis for saying, I am only talking about things that could threaten or lead to threats against actual individuals who will partake in the trial.
On the Georgia case, we've got the Jeff Clark argument now moving the case to federal court. We already saw a federal judge shoot this down in Mark Meadows' case. Does Clark have any better shot, or is this just kind of going to be the sort of drumbeat of perhaps fairly tedious hearings and filings we see in the Georgia case going forward?
It seems that Mark Meadows actually had the better argument, and he failed in that argument before the judge. His argument that as chief of staff to the former president, he was really one with the president. He had to make phone calls, he had to make arrangements, and there was really not much airspace between Donald Trump and Mark Meadows. I think Jeffrey Clark is in a very different position. He is within the institution of the Department of Justice, and he was in the environmental law section. I mean, there was really no overlap between his job duties and detecting or addressing election fraud. So I think Mark Meadows had the better argument, and again, he did not prevail in front of this judge. So I think Jeffrey Clark's chances are even less than Mark Meadows.
And really quick, while I still have you, the other big legal news today, Hunter Biden's lawsuit against the IRS. Do we think that has any merits?
And Garrett, the disclosure laws with respect to people's tax returns are very, very stringent. I think most people would be surprised by how stringent they are. And what happened here is that this is not a lawsuit by Hunter Biden against the whistleblowers. It is a lawsuit against the IRS, saying that you are not carrying out your duties to protect individual taxpayers' information. And even if whistleblowers are allowed to go to Congress, and even if Congress is allowed to then disclose information, those whistleblowers cannot then go on national news and give interviews to news media and either confirm or add to that disclosure of taxpayer information. And it's not just the information on the tax return, it's also information regarding any investigation of that taxpayer. And so I think there's some merit to this lawsuit. And apparently Hunter Biden has decided that a good defense includes some offense.
All right, well, buckle up. It's going to be a very interesting fall with all of these cases percolating. Carol Lam, thank you for your analysis.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.